Good afternoon, everyone. We're welcoming participants to this webinar. Give it just a second. Okay, I think we're getting a lot of people in. This is going to be one that starts on time. All right, I want to welcome everybody today to our discussion about local control of data centers and the different options and opportunities. I feel very lucky today to have our presenter, who is Steve Anderson, who is amazing and a longtime friend of myself and Illinois Environmental Council and the Clean Jobs Coalition. Steve Anderson is a lobbyist in Illinois with the Necritz, Amdor, and Anderson Group, LLC, and he provides guidance to those seeking to advocate in the Illinois State Capitol. Prior to his lobbyist work, he was a commissioner of human rights for the state of Illinois, appointed by the governor. He's also a retired member of the Illinois House of Representatives. He led the initiative to end the budget standoff, the largest state budget impasse in U.S. history. He also was the chief Republican sponsor of the Equal Rights Amendment and successfully passed the amendment, making Illinois the 37th state to pass the ERA. So, a very accomplished person. And with respect to this work, Steve has been a licensed practicing attorney focusing on elder law and municipal law since 1992. We're really thrilled to have him today. And a few logistics items as we're getting people to join. If you are an attorney looking for CLE, Hannah will put in the chat numerous times a Google form for you to fill out. Feel free to estimate the time that you're leaving. We can double check it with Zoom, but please fill those out as soon as possible. We are hoping to submit that by the end of the day. I know a lot of you are looking for CLE before June 30th, so please fill out that form, and you do need to have it completed by the end of the day, or we won't be able to give you credit. If you have questions, you should try to put them into the Q&A, but we also will take them in the chat. So I will moderate questions at the end. Steve is going to go through his slide, introduce himself, and start the webinar. So, and if anybody has problems with hearing audio on our end, but I think everything sounded good in our test, please put that in the chat. But we're really thrilled to have everybody here today. And I will kick it to Steve to introduce himself.
Well, thank you, Jen. I appreciate the introduction, and I appreciate the opportunity to speak with everyone today. We're going to go over, I have a PowerPoint presentation that we're going to go over. But before I do that, I'm going to take a point of personal privilege, if you will. And that is that my longtime senior partner in my law firm was a gentleman named Gary Mickey. Gary started practicing in 1966 and unfortunately passed away yesterday. And so probably not very many of you would have known him, but I knew him well. He was a mentor and really influenced who I am as a person and as an attorney. So I just want to acknowledge that and dedicate my presentation today to him. Thank you. Thank you all for that. And now I'm going to share my screen, hopefully. There. Hopefully everyone can see that. So as I said, or as Jen said, this is a seminar about local controls to governing data centers in Illinois. A couple of prefatory notes. One, this is not an advocacy seminar. This is a CLE, continuing legal education, specifically designed for that. So I am not arguing for or against data centers. I'm not arguing for or against municipal power. I'm trying to outline specifically what it is today. And that's important to acknowledge as well. What I'm talking about is today's law, not what might be proposed by the Power Act or by any other legislation in the state of Illinois. That is beyond the scope of this. This is about what we do today or what options municipalities have to work with their land use controls in their various municipalities and counties, by the way. The other thing is that I'd like to preface by saying that nothing I say should be new to a municipal attorney. Um, Everything I'm going over is pretty well established law. The reason I say that is that it's important for advocates to know what municipal attorneys know. In other words, I originally designed this to help advocates not to try to surprise a municipal attorney or not to sneak something in, but instead to be able to say, okay, attorney for municipality so and so, I understand what you're saying. What about this? In other words, it's a toolbox of options that exist. But again, nothing that should be new to any experienced municipal attorney or anyone else in that field. The other thing is that this material are options for municipalities. They are not mandates. And I should probably move the screen. There. See, I'm saying this stuff, but I forget to hit the advance the screen option. So these are options. These are not requirements. In other words, you can't tell the municipality you must do X, Y, and Z because Steve said so. Number one, never say Steve said so because this isn't the practice of law. This is educational. Never say Steve said so anyway. It's not a good plan. But what I would suggest is that you can go to a municipality and say, did you think about this? That's the point of this. But municipalities get to decide which of these options they want to employ in deciding how their municipality is organized, how they operate, particularly in the land use planning field. But understand their power is not absolute either. Um, they don't have the absolute right to deny something, typically. There are a few exceptions, but typically they don't have that option. Just as a citizen doesn't have an absolute right to demand something of a municipality. It cuts both ways. And ultimately, that's why we have an appellate process for municipal decisions. And we'll go over a little bit of that as we continue the discussion. But understand it cuts both ways. Municipalities have broad powers to decide, but not complete. Advocates have broad powers to convince and persuade why one particular approach would be better than another, but that's also not absolute. So if we understand those as the ground rules, we can continue. If I can get this to move. Whoops, I apologize. I'm going to have to. I think I just lost my, I think I just lost the PowerPoint.
Do you need us, Steve?
Could you do it?
Hannah, can you share the PowerPoint?
1 second.
I'm going to try to get
You
that.
should stop sharing for a second.
Okay.
Maybe try sharing again, see if you can find it. Otherwise, we'll get Hannah to do it.
Okay, one moment. And I apologize for this.
No, no. Everybody understands tech.
One moment. It's coming back up. Sort of.
All right, let's get Hannah, do you have it open?
Yes, give me 1 second.
Okay, Hannah's gonna share.
Okay, great. There we go.
Wonderful.
I just need to
Back on
figure
track.
out.
We could go to slide 3 and go from there.
There we go. Is that showing up okay for everybody?
It is. Thank you, Hannah.
Yep.
Lovely.
Thank you so much. So, as I said, bearing those kind of rules in mind, let's talk about some strategies. So number one is the concept of a moratorium. This is important when talking about a new type of use. It is not common if, for example, someone wants to bring in a logistics facility or something like that, because those are pretty known entities. We understand them. We know what they do. We know what they don't do. That we understand the demands of traffic and utilities and things like that. So a moratorium is not for everything, but it is a very valid and appropriate consideration when you're talking about a new use. And I would certainly argue that data centers are a new use, a new type of use that we're still learning about. And quite frankly, at the rate of technological advancement, let's be honest, it's going to continue to change. So the concept of a moratorium is that for a brief period of time, and I do mean brief in relative terms, uh, the community effectively bans the use. And what I mean by that is, let's say that a data center wants to come into a given city. The city says, whoa, hold on a second, even though it might, there seems to be an echo. I apologize if there is.
Nope, you sound good,
Uh,
Steve.
okay. Um, so some developer comes in, wants to build a data center. Municipality can say, well, hold on a second, and they can make a determination by their city council, by their village board, that they want to evaluate it more carefully before saying yes, no, or maybe, or with conditions. The purpose or the procedure for doing that is effectively the same as a zoning amendment. And the reason that I say that is by banning a use outright like this entirely, that might otherwise fit, you are amending your zoning law. In this case, you're amending it almost entirely because you're just outright saying no for a period of time. So if you wish to do that, that can be fine, but there are two elements that need to be fulfilled. Number one is the period of time has to be reasonable considering what research needs to be done. And number two, you have to follow the normal process for enacting a zoning amendment because that's what this is. So that requires public notice, a hearing in front of presumably the Plan Commission or the Zoning Board of Appeals, making findings of fact about why it's appropriate to have a moratorium, and then ultimately an ordinance being drafted and enacting it that is presented to the city council or the village board of trustees, who then would vote on it to presumably pass it. That process is well known to municipalities, so that shouldn't be difficult for them to put into effect. The more important, assuming they do that correctly, the more important aspect is the time frame, the duration. I recommend in the 3 to 6 month range. However, there have been 12-month moratoria. And it is highly fact specific. So you can't take this as a bright line rule. It all depends on your community. It depends on the particular facts of your situation. You may have a proposed developer who wants to come in that you're imposing this moratorium on, but you also might not. You might be in a position where you're saying, we're worried that one might come in, or maybe you want one to come in. But either way, you want to study it so that you do it properly. And in doing that, you have to determine, is this going to take a month or two, or is it going to take a year? I would hesitate to advise anyone to go more than a year. I think that most things can be evaluated on an objective basis within that time frame. Although, like I said, don't take it as a bright line rule. Maybe there will be exceptions to that. One exception to this concept is the slide at the lower right there, which is the concept of vested rights. This is old school common law concepts. So you have zoning laws, and right now, let's say that the zoning in a given community allows a data center. And so somebody applies for it. They buy the land and they apply for it. They submit their building permit, if you will. Maybe they don't even need a zoning change. Just depends on the municipality. And they submit. At that point, an argument could be made that even if you declare a moratorium, it does not apply to them because they had expended funds in reliance on the existing zoning. So this is a cautionary tale. You could end up in a situation, if you don't do this ahead of time, where someone could possibly do that, where they would then have the right to move forward even though you have a moratorium. So something very, very specific, but it is a valid and recognized concept in municipal law, the idea of vested rights. How much money is required in order to trigger that vested rights is, again, very fact determinative. So you're going to need to to determine was it enough to buy the land, or did they have to expend money on engineers and planners and all the other things that people do to develop land. It'll be a question, but it is something to be concerned about and an argument for why you might want to consider a moratorium for your community before anyone comes in and proposes a use. Next slide, please. There we go. So question number 2, can a municipality outright ban a data center? And this involves a distinction between home rule municipalities and non-home rule municipalities. For those of you who are not familiar with the concept, home rules are generally over 25,000 population, and non-home rules are generally under 25,000 population, but there are exceptions. For example, the city of Rockford, which is well over 25,000 in population, is non-home rule, because they had a referendum after they turned home rule to remove that authority. They're rather famous in that regard. It's also possible to do it the other way, which is that a small community, a community of 2,500 people, could have a referendum on the ballot to seek home rule ability. So you can, generally, if it's 25,000 or above, you're probably pretty safe in assuming they're home rule, but not always. And the reason that this is important is because the Constitution of the state of Illinois distinguishes the abilities of these municipalities in what they can do. And as I indicate there on the screen, home rules can do anything that's not prohibited by the Constitution or by the General Assembly. So Katie bar the door. They can decide whatever they want to do. They don't have to rely on the municipal code. They can, and most of the time do, but they don't have to. They can create their own systems, their own methodologies, their own procedures. All of that could be subject to challenge, but not simply because it's not in the municipal code. On the other hand, non-home rule municipalities, they are subject to only what is permitted either by the Constitution or more commonly by Illinois law. So that would be the Illinois Municipal Code, which is found at 65 ILCS 1/1-1, et cetera, et cetera. That's where all of the authority. However, it's not unlimited. So for example, and if we could advance the slide one, I think. No, go back. I apologize. So, for example, the question of whether or not municipalities can just ban data centers, period, the end. I think a home rule can, because again, I don't see anything in the Constitution or the General Assembly saying they can't. However, non-home rules, the municipal code provides that communities can restrict, allocate, design their districts to accommodate various uses. And so that concept is less clear. It doesn't say prohibit. It does say prohibit from some districts, but it doesn't say prohibit entirely. So I have certainly seen arguments from attorneys saying if a community doesn't allow every use, at least somewhere in the community, they are violating the Illinois Constitution. Again, non-home rule, not home rule. It's an interesting argument. I think there actually is a very good way to avoid this argument, and that's for communities in their zoning ordinances to provide for a compatibility provision. It shows up in the interpretation sections of most zoning ordinances, which says, look, if we didn't include a specific use here, look to something in our list of permitted and special uses that is kind of close. And if it's kind of close, it can go in that district. So by way of example, if a data center is not listed, which would be pretty common right now, that they're not listed, I would say look towards logistics facilities, big operations. Look towards electrical power plants, things like that. Kind of the opposite. Those produce power, data centers consume power, but they have some similarities. And so you would say if you can put a data center, or if you can put a logistics facility in this particular district, then probably you can apply for that permit in the same district for a data center. If we could go to the next slide, please. So, but that is an important question, whether or not you can outright ban. I would take the conservative approach personally and assume you can't outright ban it. So you would look to compatible uses that are listed. Now, here is next tool number 3 as it's listed. Tool number 3 is important because this is where you really have some power to regulate a use, not ban a use. Banning a use is pretty difficult, like I said, but regulating a use is perfectly appropriate for municipalities. In fact, I would argue it's one of the most important things municipalities do, is making sure that we design our communities for the benefit of all. And simply allowing everything in one district without condition is a really, in my mind, questionable procedure. Fortunately, most zoning laws already know this, or most communities in their zoning ordinances already know this. And so there are things called special uses, conditional uses, planned unit developments. There's even one called a variance. However, variances would not really apply to the circumstances here, and I can explain why briefly. But the first 3, they're all basically the same thing. And what they say is that instead of something being a permitted use, where you can simply, if I want to build a single family house in a single family zone, I'm pretty much entitled to do that, setbacks and things like that notwithstanding. I'm entitled to do that. But I'm not entitled to put a data center into an R1 zone, a single family use zone. But I might be entitled to put it into an industrial area. But even that, I would recommend that you consider imposing it as a special use or a conditional use, which are synonyms effectively, where you say, yes, it can go into an industrially zoned area. However, it's got to meet conditions. We've got to determine that it's appropriate, because even though, yes, it's kind of like a lot of other uses that are industrial in nature, it's not exactly the same. There are differences. And so by making it a quote special use or a conditional use or a planned unit development, which is a subclass of special use, each of those allows you on a case-by-case basis. So you don't have to do this beforehand. In other words, as long as the data center is listed or can be reasonably interpreted as being a part of a special use, then on a case-by-case basis, the community can review whether or not particular conditions can be imposed that would make it palatable to have a data center. Okay, so how do we do that? Those concepts are objective. This is not subjective information. So it's things like, what are the neighboring uses? What do the property owners across the street and down the block, what do they use their property for? Will this consume a massive amount of energy, a massive amount of water? I'm not picking those at random. We know that data centers do use those things in great supply. How is that going to affect the overall supply of those things for the remainder of the community? Are there fire, health, safety demands? Are there traffic issues? Even stormwater detention issues. In other words, if you're going to build an enormous impervious building, what do we do with the stormwater? All of these objective factors can be used to determine whether or not the use can be allowed. It also affects property values, right? I've never been to a special use hearing where somebody hasn't said this use that they don't like is going to devalue their property. It's very common, and it could arguably be true depending on the circumstances. So those are all things that can be evaluated. I'll get to it in a minute, but they're called the LaSalle factors, which are these objective things that courts have said is appropriate. Now, if you go through that process, and that process is public hearings, at least one in front of probably the Planning Commission, but it depends on the ordinance, at least one, but it could be more than one public hearing. And I would actually encourage it to be more than one to make certain that the public has an ample opportunity to go ahead and make their opinions known. But if you go through that process and the municipality ultimately determines that yes, with certain conditions being imposed, this use is palatable in this particular district, they can pass that ordinance granting that. On the other hand, It's not a guarantee. Just because it's a special use doesn't mean you can objectively fulfill those various standards I just mentioned. So it is possible at the end of the Plan Commission hearing that they will say, no, there are too many things that are going to be affected adversely. This use cannot reasonably fit in this district. And as a result, they can deny that use. The Plan Commission will typically advance that to the City Council or the Village Board, as the case may be, and then the ultimate decision is that of the City Council or the Village Board to affirm or deny the Plan Commission's recommendations, either approving it or denying it. Could be either way. Ultimately, it's the City Council that's going to decide that. Once that's done, the second question is, well, if they say no, can a data center appeal that? The answer is absolutely yes. And the same answer is yes if the community feels that they have been adversely impacted, but in a slightly different way. Clearly, the data center has the right to appeal because they're the ones who presented the application. So they can go to a court, and then a court can review the case that was presented and determine whether or not those standards have been met or not, and determine whether the conditions that the community were going to impose are reasonable or not, or whether the denial was appropriate or not. So the developer can do that. For a community member, it's not simply any member of the community. It has to have be someone with standing under the court system to determine whether or not they've been adversely affected, uniquely and particularly. So that could be a neighbor, would be probably the most common. Also, the community itself, the village or the city, certainly has the right to defend its decision, if you will. If we could go to the next slide, please. So again, this just summarizes a lot of what I just said, but these are the typical LaSalle factors, and that's based on a case called LaSalle versus the County of Cook, I believe. It's a very old case, but it remains the situation today in Illinois. And by the way, even though it'll be called other things in other states, the same rules apply in other states. So you can see the conditions for determining whether you can deny it or not deny it. Existing use and zoning, property value impact, like I said, the public welfare, relative gain versus cost for having the data center in your community, the suitability for the property. Vacant time is always one that people ask about. That's a question of whether or not that property has any value absent the use. In other words, if it's been absent or it's been vacant forever and nobody can ever find a way to develop the property, there might be an argument in favor of a data center. Whether or not the proposed use at that particular location is consistent with the comprehensive plan, and of course, whether or not the community actually needs it. That may or may not be true of a data center. Like I said, for purposes of today, I am neutral on that topic. But those are the sorts of objective, and if there's one thing you take away from this, it's the objective nature of these conditions. If we could go to the next slide, please. Thank you. So a question that I have been asked is, can public opposition or health impacts justify denial? So public opposition is important. That's why we have public hearings. But can it just simply be that we don't like it and enough people don't like it that we want to say no to it? My answer to that would be no. And that's why I keep saying, if you remember anything, remember objective. The LaSalle standards are objective determinations of whether or not the use can be adapted to the community or not. Public opinion is not a LaSalle factor. It's not objective. It's by its very nature subjective. Now, having said that, we all know that our elected officials are elected, and many of them would like to stay elected. So is it possible that you can influence the determination of whether or not the LaSalle factors are met by the elected officials who will be called upon to vote? Certainly, absolutely. But is it, straight up by itself? Can we just file a petition that says, 1,000 people in the community hate this idea? That's not going to be enough. It needs to be defensible based on objective standards. So when I said right at the very beginning that communities have a lot of power, they do. but it's not unlimited. And this is an example of that, where they have to comply with objective standards. Whether those are met or not, that's something to be voted on, and that's maybe where the political process can be benefited for advocates. But just understand it's not completely a given. And the other aspect of the question was health impacts. Can those justify denial? And in my opinion, that answer is exactly the opposite. It is absolutely. If there are things that are adverse health, that goes right back to LaSalle factors and could be huge. In other words, it may be that a health factor, I don't know enough about the technology of data centers to say this, but if there was something about data centers that was inherently um, uh, dangerous to human beings, that would be a totally valid reason for saying you can't have one of these, at least anywhere near where human beings live and operate. So the answer to that is yes. If we can go to the next slide, please. All right, my favorite municipal tool in the whole world is the annexation agreement. Remember how I said municipalities have limits to their authority to negotiate things? This is about the only exception to that rule where they have almost complete authority. And understand what annexation agreements mean is that there are properties that are not currently inside the village or the city boundaries, but the city has the ability, if it's contiguous, in other words, if it basically is attached to the community, the city has the ability, or the village has the ability to annex it and make it part of the community. That's how our communities grow in size. City of Chicago wasn't always the size it is now. It went through myriad annexations to have that happen. Now, if a community decide to do this and they just annex the property, but they don't enter into what's called an annexation agreement, they may have made a huge mistake. But if they do, and this is why I say none of this is a surprise to municipal attorneys, if they do negotiate a pre-annexation or an annexation agreement, they're the same thing. They can impose virtually any condition at all. There are no limits in effect to what can be imposed by an annexation agreement, with the exception of the constitutions, the U.S. Constitution and the state of Illinois Constitution. They can even override an annexation agreement, legislative enactments. So they can negotiate almost anything. And I give an outrageous example of this only to show exactly how powerful it is. We could have a community. I'm going to pick one at random, which is one I used to represent. Okay, it's not random, but we could pick the village of Montgomery in southern Kane and northern Kendall County. And they could decide to annex a parcel of property for some residential development. And they could say in that annexation agreement, the condition for you to be able to do this is if you agree to build a Bears stadium in Hammond, Indiana. Apparently, they don't like the Bears. I'm teasing. People in Montgomery probably love the Bears. But they say, we want you to build that. It has nothing to do with the village of Montgomery. It has nothing to do with the development at all. Completely irrelevant. And yet, an annexation agreement, that would be legal to do. Now, would anybody actually agree to sign that annexation agreement? Of course not. It's a ridiculous example. But the point of the example is just to say how powerful these are. So when we then we go back and we talk about LaSalle factors and how they have to be objective, that's no longer true. So if the property that a data center wants to go on to is not yet in the village, but they need the village for something, probably water, for example, probably municipal utilities, then the municipality has the ability to negotiate terms. And it can do things outside of the question of the LaSalle factors. In other words, if they want to say, we really want a job training program for our city or our village. We want you to fund it, to the tune of $1 million a year. They can do that. I don't know if that number is realistic or if that condition is realistic, but can they do it? Yes. Can they say, we want all of your energy to be based on renewables? Yes, they can. They could make that condition. Could they say, we want you to bring your own water, so to speak? I don't know how you do that, but, a way of doing that, if there is a way of doing it, you could demand it. Now, it is it is possible the data center will say, no, we're not going to annex them. We don't want that. We can't live with those conditions. So it is a negotiation. It's not like they can impose them and the data center has to accept them, but it is possible to negotiate quite a bit more in an annexation agreement than anywhere else. Now, my fourth point, which is a little in yellow and green, is be a little careful about this, municipalities. If you push too hard and you can't get to agreement, it is possible they could build on that same site, not in the village or in the city. They could just build in the county. Maybe the county regulations are easier. Maybe they can drill a well and they can get all the water that they need, and ComEd or Ameren, as the case may be, can go ahead and connect them because it's not a municipal utility. If that's the case, you might be cutting off your nose to spite your face. So you have to understand, while there is substantial leverage, it could be that you don't have all leverage, which is always the case. If we could go to the next slide, please. Thank you. Oh, and I just explained this. So the caution of refusing to annex. I won't go through the slide because I really just did. Be careful. That's all I'm saying. Don't assume that saying no to an annexation means that you've just stopped that development. You may not have stopped it at all. Next slide, please. Utility controls are another regulatory lever. These are not things that could make the development an absolute denial, although water might be, depending on the conditions. So these are your utilities. So water and sewer is typically governed either by the municipality or by a sanitary district, which sometimes is separate and distinct from the community. Electricity sometimes is a local issue. Sometimes, as I mentioned a moment ago, it is not. I live in the city of Geneva. Geneva has local control over its electricity. And of course, rate making can be in effect as well, where you might differentiate between the consumption, the volumetric consumption of power, so that you could at least say that the data center is using its or paying its fair share for what it's doing. The reason I hedged a little bit on water is a very limited resource if you're not next to a river or next to Lake Michigan. If you are, like most communities in the state, reliant on groundwater, that is a limitation. And so let's say you've got a pretty well built out community that's been using an aquifer for a very long time, and you're not sure, because we don't really know how much water is in an aquifer to any great certainty. We do measure, the engineers do measure, but it's not at all certain. It might be very dangerous for the water supply for the community if you simply allow a data center in. So that's one that could be a basis for denial, where you simply say, we cannot do this because you're gonna drain us dry. The only way you can do it is if you find a way to bring your own water. I don't know how you do that, but if that were possible, I suppose they could do it. Next slide, please. So can you single out a data center? And this we're back to we're back to the concept of, how do we classify a data center? How do we zone it? The question is, can we say that a data center is a unique and different use? And my answer is yes, you can. Just as you can say a logistics facility is different from a manufacturing business. Caterpillar is an enormous manufacturing facility in the communities that it lives in. It's not a logistics facility. They're different. And similarly, a data center is not a logistics facility. It's not a manufacturer. So I think it's entirely appropriate for you to go ahead and make it in your municipal zoning code a distinct use. And thereby, you can also make sure, at least I would, make it a special use, so that you can impose conditions that we talked about earlier. Next slide, please. Thank you. So shifting a little bit away from municipal to county powers. Counties are similar. Typically, counties do not have the same robust zoning controls that municipalities do. I can't exactly say why that is, because they are legally authorized to have the same levels and the same types of things like special uses and PUDs. They can impose moratorium, and they certainly regulate their land use. So it really does mirror it. But at the same time, my experience has always been that counties don't go quite as far. Maybe that's just the nature of it being a county and not a city, that people in the county don't want as much regulation, perhaps. And they want a little bit more freedom and flexibility than you might have otherwise in a municipality. So, again, can they? Yes, they can. A couple of things they can't do. They are not home rule, except cook. That's just a statement of fact. So they don't, they have to abide by the General Assembly's laws on on county governance, their statute. So if you don't find the power to do something in the county's codes, you can't do it. You have to be able to point to it and say, this is the authority for what we're doing. There are no annexation agreements because all of the land is already in the county. So that broad power, that doesn't exist. And the utility controls are typically weaker because oftentimes the county isn't providing many utility services. They typically wouldn't do electricity, and oftentimes they don't do water. Many people living in counties sink their own wells. There are things like water districts that can exist, but typically the counties are not doing that. And like I said, they must stay strictly within what the state authorizes. Now, an interesting thing that I learned in the last year, I knew it was possible, but I didn't realize how common it was how many counties in Illinois don't have zoning. I mean, nothing. They don't have zoning at all. I thought, well, sure, in theory, but probably there isn't any, or maybe there's only a few. About 40% have no zoning. 40% of counties in the state of Illinois have no zoning control. That shocked me. I'm not telling you it's right. I'm not telling you it's wrong, but it certainly limits what counties can govern. And that might be precisely the reason. It might be, I'm guessing this is downstate. Like I said, I don't know the counties. I'm guessing it's downstate. Maybe it really is an area where people believe their home or their land is their castle, and they really want the government to stay out of it. Well, this would be a way to do it by not having zoning. And so another question that kind of inherently comes up when I say that is, well, what can advocates do? What can people do if we've got a county with no zoning and a data center wants to locate there? Well, number one, even though a county doesn't have zoning, it's quite likely that the cities within that county do have zoning. So perhaps, remember back to the annexation agreement, perhaps you can compel the communities that are there to try to annex that property if they're close enough. That would be one remedy for advocates to have, is to try to force that property into a given village or city. It's not a given, it's not an absolute, but you could attempt that. The other thing, interestingly enough, relating to cities and villages, they have extraterritorial powers. Basically, they have the ability to regulate subdivision development for a mile and a half outside their boundaries. So even though their boundary is here, another mile and a half out, all the way around that community, they have some regulatory authority. It's not zoning authority. It's not the description of special uses and things like that. It's more like the how you design the streets, how streets are constructed, how blocks are laid out, things like that. And the reason, the logic behind this is simply that at some point, the legislature anticipated that that mile and a half, that the community will grow into those areas. And so if they develop before that happens, it'd be nice that at least the streets and the relative layout is consistent with that of the municipality. So it's not designed to be a zoning governance issue. So there is some danger there. The other thing that, in answer to the question of what can you do if you have no zoning, is look to those other potential districts. There are things like sanitary districts. There are water districts that can determine how many wells can be drilled in a given area. The idea there is that, like I said before, you might drain that aquifer, and that's not good for anyone. So those are separate municipal or separate local entities. And by the way, it might be easier to set up a water district than it is to form a municipality. So maybe that's something that is an option, depending on, what your circumstances are and whether or not you actually wish to do that. But those are a few of the things. But when I'm asked that question, what can we do if we don't have zoning in our county and they want to put a data center there? The answer is they probably have a pretty good shot at doing it. I'm not going to blow smoke and say, oh, you can stop that. The answer is you might not be able to stop it, and they might be able to develop quickly. So if there are any municipal officials who are from counties that don't have zoning, my own personal recommendation, it's not legal advice, but it's a personal recommendation, I would consider strongly imposing some level of county zoning authority in your communities. So there's my editorial. Next slide, please. Thank you. So we're at 12:45. I've got a few more things to talk about, but I did want to summarize these things, and then I know Jen asked me to go ahead and open it up for questions. These are the basic concepts. Like I said, don't let it just be a permitted use. Please don't do that. I mean, even if you want them, even if a community wants them as a use, please make them a special use so that you can impose conditions and protect your community by doing that. Do consider a moratorium if you have not studied the issue. I think it's terribly important that something as advanced as this is, and I think as much as it's going to change in the next few years, because we don't know where AI is going to go, I think it is critically important for us to understand the demands of these facilities. And think about this. What happens if the advances in technology end up eliminating the need for huge data centers, the ones we just built? Now you have a community that developed one or permitted it to be developed in their community that isn't necessary anymore. Now it's a white elephant. You have this enormous building that you don't know what to do with. Maybe you ought to give some consideration as you're negotiating an annexation agreement, if you have one, or maybe one of the conditions for a special use is how do you wind it down if it ever shuts down? It's a consideration, but I think you should do that determination. You could make those sorts of you could ask those sort of questions during the moratorium process. So I think that educational aspect, regardless of whether you want these or not, is a very important step. Number three, I've said so many times, you're probably tired of me hearing it, but classified as a special use. When you do, and now you have to go through hearings, use those LaSalle factors. I know public opinion is important for elected officials. I understand that. But if you want to win in the appellate court, if you're challenged, use them. Document the facts, the reasons behind why you said no or why you said yes, but with a certain number of conditions. Because it is possible that a data center who you say yes to, but you impose some onerous conditions on, might still appeal that decision. They might still say, that's not appropriate. You violated those LaSalle standards, and so we want a grant that is less onerous than what you've given us. So I really encourage the objective, the careful consideration of those. Employ the experts that you need. Most municipalities in the suburban areas, they have either on staff or on contract, they have civil engineers, they have planners, they have public works folks who understand these things. But if you don't, hire them. It's worth the investment. And by the way, you can require, as part of your zoning ordinance, I didn't mention this, you can require a deposit for any special use that you might be considering. In other words, you could say, yeah, we'll consider your special use, but you got to deposit $10,000 per acre for consideration and processing. So you will have the ability to afford those experts. So use them. Like I said, if you can annex the property, leverage that. It's a great power that gets you the ability to maybe negotiate more than you otherwise could. And of course, always ask the right questions, make sure you're talking to everybody on every side of this equation. And by doing that, you'll be able to really, I think, make an informed decision. And then last thing, I think that's the last slide. Could you verify that for me? Looks like
Sorry.
it.
Yes, that is the last slide.
Thank you. Thank you. So one of the things I wanted to talk about before I open it up to Q&A is that the thing I didn't talk about here are incentives. In other words, most of this is about defense, if you will. Whether or not you want it or not, how do you defend your community against just someone running roughshod over your community? It may be, though, that some communities do, in fact, really want them, want to court them, and want to make them a part of the community. Again, I hope you use the standards I've recommended to make sure you do it well, but you can also use incentives. So things like TIF. If you've got property, remember I talked about vacant property? If you have property that just can't development, maybe a TIF is an appropriate way to incentivize something like that. And this, by the way, for the advocates who would think, why are you telling them this? They know this already. But the idea here is that there are ways to improve your community if you decide that you want to tolerate something like this. TIFs, tax rebate agreements, those are other things, but all of them can be combined with annexation agreements. All of them can be combined with special use considerations. So do your very best. That's I guess my final word on the topic is do your very best for your community. I know you do, elected officials, but to balance all these interests to come up with the best solution. And advocates, I hope that you use all of these tools to ask those right questions of your community leaders, your elected officials, your experts, so that everyone has full and fair participation in this process. And with that, I'm going to say thank you and give it to Jen to moderate if there are any questions.
Yeah, thank you. There's a ton of questions, Steve. So I'm gonna try to keep this to 10 minutes. But a lot of great questions. So there were a couple questions up front. Both Christy and Lori asked a little more about public notice rules, and the other question was, are there qualifications around what a public hearing is? Like, is a city council meeting or committee of the whole a public hearing? Do you want to just comment on how folks can find out more information about public notice and public hearing requirements and how they could be enforced?
Sure. So there are specifics, and you'll find them both in the municipal code of the Illinois statute. So that's 65 ILCS. I think it's in section 5/13 is most of the zoning requirements. So you'll find the public notice requirements. They're typically 30-day notices. They're usually required to be sent to any landowners within about 250 feet or 500 feet for the area that's sought to be developed. There's usually also a publication requirement. Some communities require posting, a big old sign right on the property, but not all of them do. So don't rely on that. So there are several different ways. As far as what can be a public hearing, there will be public hearings both at the lower level. So the Plan Commission or the Zoning Board of Appeals, they have public hearings, and also at the City Council or Village Board. And a committee of the whole was asked. A committee of the whole is effectively a village board or a city council meeting, but one that they typically don't take votes at. So it's a little bit more open-ended, but all of those can be public hearings. The most important aspect of a public hearing, though, is that the public has a right to ask questions and to participate. And that is what makes something a public hearing. It's not just a presentation by the developer and questions by the city council. The public has a right to be heard and has a right to interrogate the petitioner. So you can ask questions of the petitioner.
Thanks. And the presentation slides will be sent out, especially just reminding people to fill out the CLE. Definitely the attorneys get the slides, and this has been recorded. Okay. If a municipality enacts a special use classification while a data center is being built, how likely is it that an ex post facto issue arise?
So that's kind of the vested rights argument that I was talking about. It all depends on how much money the developer has invested in the project already. If all they've done is bought the property, that isn't much of an investment because they probably bought it at market rate, which means they can probably sell it again at market rate. But if they have invested a ton in engineering and structural and all the things that you need to do to make a development like this happen, the more they spend, the higher likelihood that there is that you called it ex post facto, I call it vested rights. Either way, we're talking about the same thing. The more they spend, the more likely it is that you might not be able to impose that. But it's a high bar. I would not give up. Like, even if you found out they did, I'd still pass the special use and let them argue about it later.
Nice. Um, okay, that's done. Can a property owner contest annexation?
So probably you're talking about an adjacent property owner.
Yeah.
Typically, yes. The people within that 250 feet or 500 feet, that's why we give them notice. So you can contest it. You'd be contesting it on the same bases that I explained with the LaSalle factors, saying, well, the city granted it, but I don't think it met these, and this is why. And that contest, other than, I should back up one thing, you can certainly contest the whole process. You get to speak, you get to make your arguments in front of the city council, you get to persuade against it just as much as the developer gets to persuade in favor of it. But ultimately, if you lose, then that's the appellate court or the circuit court and the appellate court. So you can, and the Supreme Court in theory, you can go all the way up the chain. It's not
Okay.
free, by the way.
Oh, I guess she was asking whether you can contest the annexation of your own property.
Oh, oh, no, yeah, you can, absolutely. There are only a few circumstances where a municipality can what is called force annex a property, and fundamentally you have to be surrounded. If you're not surrounded, they can't annex you without your consent.
Cool. And I'm doing the Q&As, then I'll go to the chats. How can one municipality prevent a neighboring municipality from allowing a data center next to their boundary?
Ooh, tough one. A lot of communities enter into boundary line agreements. Those boundary line agreements can extend to that 1.5 miles that I talked about, so way beyond the current municipal boundaries. And they can draw a line and they can say, this line, this is what we agree. What goes here is for us to decide. What goes there is for you to decide. That's the best way to do that. Excuse me, pardon me. In the absence of that, very little. They can have the same public input. Neighbors from the neighboring municipality can appear. You have every right, regardless of where you live, to contest it. But ultimately, the municipality that is going to control that property is the one that's going to make the decision.
Okay, I got all in the Q&A. Let me see if Kevin had a question. Um, you want to know the importance of the city attorney advising their planning and zoning commission, as well as city council, to refrain from commenting on or stating their position about a proposed data center until and when the matter is before their respective regulatory body. In other words, preventing the city from being sued by a proposed developer that the objectivity of the public process was not made, and that PZC or CC made up their minds before the due process procedure and protocols were allowed.
That is an excellent suggestion. Even though it was phrased in the form of a question, it's actually a very good piece of advice. Number one, always listen to your municipal attorneys. They're there to protect the municipality. They do serve at the pleasure of the elected. So I'm saying that to the electeds. The advocates, I would trust them, but verify at the same time. As far as the electeds opining before all this, yeah, I would really recommend against it. You have every right. You have every right. You're an elected official. You can do what you want, but you're hurting your case. Because if you already have decided before those LaSalle factors that I keep harping on, before those are considered, you basically said, I don't care about all those. I'm just voting my whim. And that would hurt the position. So I would urge you to not do that.
Thanks. And just for folks, we will follow up with the YouTube recording and the slides, especially for attorneys. I'm just going to take, um, Okay, I'm just going to take this water district involvement. I'm sorry. And that's going to be our last question. And just can you talk a little bit about how a municipal, I'm assuming municipal water district because
It's not municipal. It's a
okay.
separate legal entity.
Hmm.
And so there's a statute that provides that any area, if you will, can enact a water district. Just like there's sanitary districts, people are more familiar with those. You can also have water districts. And water districts can basically regulate the amount of wells that can be sunk. They can regulate the process for sinking a well, for the conditions that allow it to occur, and they can also regulate the how much you're going to withdraw out of the aquifer under those circumstances. They're not super strong. I'm going to be honest with you. The statute has not fully been fleshed out because there are not a lot of them, but they have been used. Back in the day, the city of Aurora was worried about other surrounding municipalities developing around them. Not they, the city, but people connected with the city, enacted a water district outside the city boundaries to limit development. It didn't ultimately work, but it can slow you down at least.
Great. All right. Well, thank you everybody for attending this, and thanks for you're definitely on IEC's email list, whether you were before or you are now, and we really appreciate your involvement in this discussion. I know that we're going to be having more webinars over the summer, particularly for Chicago Climate Week and other pieces. Um, if you are an attorney, please make sure you fill out the CLE form today so we can get you that to appear. It might not appear until August, even if we file it today, but we will do our best. But thank you so much. And thanks for supporting Illinois Environmental Council. And that was a really great presentation, Steve. We appreciate you so, so much.
My pleasure. Thank you all. I enjoyed it.
Great. Thank you.